A very good morning to everyone present here. On behalf of everyone at DMHSL School of Law, HSNC University, Mumbai, it gives me, Prerna Loni, immense pleasure to be your host this morning. Our esteemed dignitary and guests, faculty members, and my dear friends, I welcome each one of you to this enriching and thought-provoking lecture that we have planned for you this morning. Today, we are privileged to have amidst us Honorable Justice D.M. Srikrishna Sir, former Judge, Supreme Court of India, and a distinguished speaker who will shed light on a fundamental aspect of legal framework, that is, the right to privacy under law. We commence this event on an auspicious note by invoking the Almighty and by lighting the inaugural lamp. May I please request our dignitary, guests, and faculty members to kindly light the inaugural lamp. As the lamp is lit, may its radiance touch each one of you, kindling in you the immortal flame of knowledge and understanding. Thank you so much. It will now be my privilege to request Advocate Anil Hari Sir, Trustee and President, HSNC Board, co-founder of DM Harish Foundation, and an eminent visiting faculty at this very school to please come and address our students.
Good morning. Good morning, sir. We are very proud and privileged to have with us Justice Srikrishna. He was Chief Justice of the Kerala High Court and a distinguished judge of the Supreme Court of India, and has chaired so many different committees on various aspects of the law and the application of the law in India. Apart from this, Justice Srikrishna himself is such a great scholar. He speaks 10 languages and has done his master's, of course, in law and also in Sanskrit, and has done a diploma in Urdu. He is very learned. It's always a pleasure to hear him and to hear him talking in different languages, many of which we don't understand, and yet he then explains everything so clearly and so carefully to us. The subject on which he will be speaking today is extremely important, but as crucial as it is also very complex. The Supreme Court of India, in the case of Puthuswamy in 2017, said that privacy is a fundamental right. Now we are all aware that the right of freedom of speech is a fundamental right, and on the other hand we find that the right of privacy is also a fundamental right. So where is the dividing line between the two? As it has been said, that my right to extend my arm extends to just a little bit before your nose begins, because I cannot say that I can extend my arm everywhere. The other person has the right to defend himself and to be away from my rights. The two rights can conflict, and this is the issue that arises in data protection. The internet today is like a time machine. You can go back into the past, you can see whatever a person has done many years ago, you can see information which perhaps is confidential because one can hack into information, one can have access to different kinds of information, and yet is it that all this information should be made public or should be available to the public? No, there have to be certain lines that have to be drawn, whereby you have a right to privacy, although the other persons have a right to information or a right to be able to express themselves. In the case of, say, extending my arm, we can see physically that it must stop where the other person's nose begins. But in the case of freedom of speech and data protection and privacy, where do you draw the line? These are subjective, these have to be done very carefully, because one must have some information about others and yet not complete information. So we look forward to hearing Justice Srikrishna speak on this very important topic, and I'm so glad that he has come to us here at DMHSL School of Law. Our School of Law is just 2 years old, but we try very hard to do as much as we can We have very distinguished and very dedicated faculty and wonderful students. I have interacted with many of them. They are also sincere, they are so eager to learn, and I'm very pleased to say that in the last 2 years, they have done well at national competitions as well. They reached, Justice Srikrishna, our team reached the semi-finals of the Wildlife Moot Court at Government Law College, even though we are a brand new college. And even in the DMHSL Moot Court competition with GLC, we've already reached the quarterfinals. So we are sure that all of you are going to do very well, and this is a chance for all of us to learn from Justice Srikrishna. So I'm very glad to have you here, sir, and we look forward to hearing from you. Thank you.
Thank you so much, sir, for your wise words. Privacy, a cornerstone of individual liberty, has evolved in the digital age, representing new challenges and considerations. Our esteemed guest speaker for today is a renowned expert in the field, and we eagerly anticipate his insights into the legal dimensions of the right to privacy. Without further ado, I would now like to call upon Ji to come and introduce our guest speaker for the day, Honorable Justice D.H. Srikrishna, sir.
Thank you. It is an honor and absolute privilege to have someone of the eminence of Justice D.H. Srikrishna to be here amongst us. Sir, you need no introduction, but for the benefit of the students, I feel that a brief highlight of your career would be necessary. If you have to reflect on Justice Srikrishna's career, two words will always come to one's mind: fearlessness and sensitivity. Fearlessness. Fearlessness is not the absence of fear. It is the presence of mind you have during approaching a situation which is fearful. Justice Srikrishna has been very famous in his level-headed and absolutely fearless approach to many problems in our society. Sir has sat on many commissions. He investigated the violence in the Madras High Court. The bifurcation of Andhra Pradesh state was also overlooked by Justice Srikrishna. Sir was the Chief Justice of the Kerala High Court, the Judge of the Bombay High Court, Chairman of the 6th Central Pay Commission. Sir was also appointed by the government as Chairman of Committee of Experts of Data Protection. Sir was awarded the 50th Anniversary Outstanding Achievement Award by International Technology Law Association, which is more to do with our topic today. When you have a lot of knowledge, it is very important to share it, and Justice Srikrishna has always done that. He has lectured in Stanford, in Bar-Ilam, in Oxford. He is a Professor Emeritus at the RV University in Bangalore. Sir, we are very grateful that you are here amongst us today, and I hope that people not only learn from your lecture, but also from your character of being a fearless and just judge. I would like to now invite the Honorable Justice Srikrishna to approach the podium and address the students. Thank you, sir.
Before I start, I must apologize. My throat is so bad that I break out into a fit of cough. Please pardon me for that. Dear friends, Shobha and Anil, I can switch off. The young man who introduced me said, I am fearless. Honestly, I get afraid when I stand in front of an audience like this, which comprises eager, excited young students. Because then I don't know whether I am able to really give them what they are expecting from me. With that, let's go into the topic. I assure you that I am not going to pick up the Data Protection Act, and it's called a DPDP, Data Protection, Personal Data Protection Act. I am not going to go section wise and analyze it and tell you what it is. That is something that your teachers will do in the class. If they don't do it satisfactorily, you will start yawning. I got it. Thank you. I got it. Now let us start from what is data. You have all heard this expression, which has been bandied about quite a bit, saying data is the new oil. What does it mean? If it means that data is very valuable, that's correct. if it means that data is some kind of a property, that is not correct. Look, jurisprudentially, property can be of two types. One is tangible, like a car, a house, a pen, a book, or something like that. The other is intangible, like your rights under the intellectual protection rights, the IPR rights. Now, when I say I am the owner of my data, what exactly is conveyed? When you say this is my property, what do you really mean? You mean that I have several rights in respect of this property. What are those rights? Let's say I am the owner of it. I'm sorry, I'm not the owner of the property. I wish I could be. A huge building like this, I'm the owner of this building. My rights include various things to build upon it, subject to the building regulations. It even extends to demolishing it, rebuilding it, building a swimming pool, a tennis court, if that is permitted under the building rule regulations. I can mortgage it to a bank, raise money. I can just gift it to somebody that I know. I can allow it to be transmitted by a will when I die. I can outright sell it to somebody. These are the indicia of a property. Now turn to data. If data is your property, which of these can you do? Now what is first of all data? Let's understand what is data. Data basically means something that is capable of identifying a human being. Now what can that be? It can be my name. It can be my telephone number. It can be my address. It can be my biometric measurements, my height, weight, etc. So if I say that my data is my property, what am I saying? Can my name be given to you as a gift? Can somebody be gifted my name and you can walk around and say, I am Srikrishna from tomorrow? You can't do it. Can I lend it to you gratis and say for 6 months? You can't. The bank won't give me money on my name. The bank won't allow it to be sold. Sorry, not the bank. I can't allow it to be sold. Therefore, this is a type of relationship in which the indicia of a property do not really apply. Therefore, we go back to the original jurisprudential concept. That when I say, it's an interesting thing, it's somewhat a philosophical thing. When you say something is mine, what are you implying? You are implying ownership of that thing. Is that correct? If I say this is my wife, can I say I am the owner of my wife? If I said that, my wife would slap me. Or can I say this is my child and the child will be given to you by free? It cannot be done. Therefore, when you say something is mine, all that you can really say is that there is an intricate, intimate relationship between that object and myself. If you take it beyond that, the test will fail in a large number of cases. So when I say something is my data, I am not saying it is my property. I am only saying that there is an intimate relationship between the data and myself. That would be correct. Because my name means so, my telephone number means this, my address means this. There is an intimate relationship. Then the next question is, does this have any value? Of course it has a value. It has a value for various other reasons. But merely because that intimate relationship has a value, one need not jump to the conclusion that it is property. Alright, now that is over. Now the next question is, why should it be protected? Of course it has to be protected because it is something that relates to me, and self-protection is inherent in every human being. What relates to me, whether it be my family, my children, my wife, my relatives, my friends, or even my property, my money, I have to protect it. Similarly, data has to be protected. Protected against what? Against misuse. So where can there be misuse? I might be interested in giving my data to somebody for a specific purpose. And somebody using it without my consent, without authorization from me, would be a misuse. It has to be protected against misuse. So these are some of the general concepts from which we go to the, oh, thank you very much. That's lovely. Now, why did it all start in India? Oh, I forgot to mention that people tell me, oh yeah, data protection, yeah, GDPR is there, we have learned from GDPR. Hey, GDPR is Kalka Bacha. In India, we had this concept of privacy much before GDPR ever came into existence, much before people even realized what it was. Way back in the 4th century, there was this famous Panchatantra and Vishnu Sharma's advice given to the princess. You know, Vishnu Sharma was a wise scholar who was appointed by the king to teach some sense to the children who were wayward. Now, one of the things he taught them was, he said, Ayurvidtam Grihachidram Mantram Aushadhamaitune Dhanam Manapamanavcha Gopyani Gope. He says, 9 things are to be kept confidential or private. What are those? Ayu. Never disclose your age. Now that is precisely followed with all the ladies, I think. You never disclose your age. And if I ask your age, you become very angry. With the bank balance. Nobody discloses bank balance. Grihachitra, your domestic quarrel. I can't come and talk to you about what quarrel I had with my wife. Mantra. The mantra that the Guru has given to you must be kept confidential and private. Aushadam, your medical history must be kept confidential. Maithura, your sexual affairs should be kept confidential. Dhanam, whatever you have given as charity must be kept confidential. You can't simply say, I paid so many thousands or lakhs of rupees to so and so. Never put it on a board. Mana apamanam, the accolades that you get in life or the criticism that you get in life must be kept under a bottle. So these are the 9 things our wisest elders taught us should be private and confidential. So the concept of privacy is there right through. Now somewhere along the line we lost track of it, and then now I'll go straight to the situation of how the thing was debated in the courts in this country. It all started with a case in the Madras High Court. There was this girl. You know, the good old days, not like present days. The usual thing that you propose a girl to somebody else and the elders decided the arranged marriage business. And that's a concept that is very foreign to all of you, I think. The arranged marriage is where the parents meet and decide that so and so's son should be married to so and so's daughter. So it happened that the daughter of the proposed bridegroom was asked by the father of the proposed bride about the health of the proposed bridegroom. And it happened that the boy had AIDS. The doctor disclosed it and said, because it's a serious thing, having AIDS is a very bad thing as far as marriage is concerned. And that became an issue, saying, how can you disclose this? This is my private affair. How did you disclose it without my authorization? So the matter landed up in the High Court, and the Madras High Court had to decide this issue, and they said, no, in a situation of life and death like this, it is justifiable to say that privacy should be breached. That was one case. Then we had an interesting case from Madhya Pradesh, where one fellow was constantly surveyed by the police. He had not committed any crime or anything like that, but the police kept him under surveillance. They would always watch him, they would always stalk him. So he goes to the court and then files a petition and says, this is an infringement of my rights. Then the High Court decided and said, yes, in the absence of any criminal antecedents, if you put him under surveillance, that is a breach of his privacy. They recognize the right of privacy. So there were a couple of judgments going this way and that way, saying this way, that way. Sometimes they said there is a right of privacy, some said there is no right of privacy. And this was in a very nebulous affair, nebulous state of affairs in our country. Then we come straight to the year 2016. 2012 onwards, Europe started this GDPR. GDPR is the privacy law in Europe. And question arose whether such a privacy law should be enacted in our country in order to protect the citizens' privacy. Now I come to my role in the matter. I had just finished I think maybe the FSLRC or something, and I was about to catch a flight to go to New York for a holiday. Suddenly I get a call from the then Law Minister, Mr. Ravi Shankar Prasad, saying, Srikrishna ji, आपसे बात करनी है, बोलिए बा क्या बात है? नहीं आपसे कई देश के लिए बड़ा काम होना है. I said, what काम करना है? You have already done enough काम for the country. What more do you want to do? He said, नहीं साहब ये कर रहे हैं. The reason why he did that was very interesting. What happened is the government of India has come out with this project of Aadhaar. All of you know what is Aadhaar. Probably everybody has an Aadhaar card also. Aadhaar is a unique identification number to every person resident in this country, citizen, not citizen. Now, when that was done, that was challenged by some of the activists on the ground that this is an infringement of my privacy rights. So the matter landed up in the Supreme Court, and the Supreme Court was concerned to decide whether it is the right of privacy is a right at all. And some of the arguments was that it is not only a right, but it is a fundamental right. And as students of law, you know the difference between an ordinary right and a fundamental right. An ordinary right can be taken away by normal legislative process, but a fundamental right cannot be taken away except by a complicated procedure that is prescribed in the Constitution. So the question arose whether it's a fundamental right or an ordinary right. And it happened that some judge very innocently or mischievously asked this question, and, hey, but what is the law on privacy rights in this country? So everybody looked around and said, where is the law? There is no law at all. So immediately, this happened on a Thursday evening. So they said by Monday, Tuesday, we'll tell you what it is. So it was adjourned. And Friday night, I get a SOS from this law minister saying, "Aapko bada kaam karna hai." What is the kaam karna hai? He said, we have to find out, we are going to appoint a committee to go into this question as to what is the law or what should be the law of privacy in this country. I want you to be the chairman of that. I agreed to it, rightly or wrongly. And then it happened that on the next day of hearing, the Solicitor General or the Attorney General was appearing, goes to the court and says, "Sir, we have appointed a committee headed by Mr. Justice so-and-so, which go into this question, it will be decided, etc., etc." The Supreme Court was placated. And to the credit of the Supreme Court, they have devoted one big passage in the judgment of Puttasuami's case, which was referred to earlier, in which they have said, the committee headed by so-and-so are given the repercussion, the government should seriously apply its mind, etc. Now, this is one aspect of the matter. So that is how this entire committee was born. When this committee was born, I had experts with me, some of them government officers, some of them private experts on this, some lawyers, some researchers. So we were going on with this work. We looked at what is the real law on privacy in Europe. The GDPR was just about to come to an end. It had not started still. Then we had what is the law in America? Zero. There was no law in America at all. In England, it was half-hearted. Singapore, Australia, South Africa, Estonia, we looked at all that. And they said, hey, right, fine, everybody doesn't seem to have a clear-cut idea of this. Let's have an idea of what it should be in this country for ours to be. That is enough for us. So that is how the committee sat down and produced the report and a draft bill in 2016. That draft bill was not immediately accepted by the government, and there was a lot of back and forth on that. And finally you saw in 2022, after so much of hemming and hawing, the act has been passed. So that is the story of how the law as to privacy developed in this country. Now what exactly is this and the principles on which it is based? First of all, data is mine. I told you when I say mine, I don't mean I have a proprietary right, but it's some intimate relationship with me. Now, I can give it to somebody for some definite purpose. When I do that, what am I called? What is the receiving person called? Under the GDPR, under all other laws in other countries, the person who is called, who gives, is called a data subject. And this was pointed out to me in the committee discussion. I said, hey look, the last time I was the subject of the Queen of England, and the Queen of England is no longer reigning this country, so I am nobody's subject. I am not even the subject of the President of India. I hate the word subject. So what should it be? Then the name was changed as data principal, and the person receiving it is the data fiduciary. Why fiduciary? You are all students, you know what the word fiduciary means, something that is received in trust. What happens when I give data to somebody? I trust and give this data on the understanding that this data will be used by the person for the reason for which it is given. So that the nomenclature was data principal is the person whose data is being taken, data fiduciary is the person who takes the data. Now, there must be some rights and obligations of both. The data fiduciaries, the data principal's right. The data principal should have the right of saying no if I don't want to give. Also of making sure that the data that is given is subject to same security as it was with me. Now if I give my money to you, I expect you to keep it like, let's say a baby or a banker. When I put the money in the bank, I expect that it will be safe there. That little bank will not allow people to take it away from there unauthorizedly. They will not allow access to unauthorized person, their security will be maintained. Similarly with my data, when I give it to a fiduciary, its security must be guaranteed. Now, that is the obligation of the person receiving the data. Number two, he must also ensure that the data is used only for the purpose for which it is given. It is only the purpose limitation test. Now, if I give my data to, let's say, you give your data without knowing it, even consciously, unconsciously, every day in the day, and we go around throwing data like the birds drop their feathers. I'm using a very moderate expression. Now, let's say I want to buy a plane ticket. I go to the travel agent or to the airline's office and I say I want a ticket from Bombay to Delhi or Madras or wherever. They will say you give your telephone number, you give your email, your address. Luckily they stop there, they don't ask for anything more. Now, this is given for what purpose? For the purpose of ensuring that the service that I demand from that person is given to me effectively. That service is booking a ticket, plane ticket for me. Now, does it authorize him to give away this data to a sari manufacturer or a sari dealer who will keep on sending me emails and saying, do you want to buy this sari, do you want to buy this sari, or do you want to invest in a tower that is built at the Cup area or something like that? No. Therefore, the purpose limitation says you shall not use the data for anything other than the purpose for which it was granted to you. Another limitation. Now let's say I go to a bank and I open an account. Again they will ask you 200 questions, you will answer them. And most of it is my data. At the end of 6 months I find that this branch or this bank is useless. I want to terminate my account for it. So I go to him and says, shut down my account, withdraw all my money. That has to be done, that is my right. But when I exercise that right, what happens to the data that is already given? Now, earlier it used to be written down in a register, but today they maintain it on a computer. So, I have a right to demand that you delete all the data that is there with you. Now, friends, all of you must have given a lot of data to Facebook, or Meta as it's called now. Meta, no, that's what it's called. Now, when you terminate or close your account, demand that your data should be deleted. Otherwise, they will transfer this data to somebody else. Make sure of that. And they send it back to you. Remember, They are bound to and they will do it. Similarly, the bank manager has to close the account and delete all your data. But there is one catch here. The bank manager will tell you, he says, sir, but there is unfortunately a very bad act called the Income Tax Act, of which our friend Anil here will be able to advise you on that, that it requires you to maintain your records for a specified number of years. It used to be 7 and it's been increased to 16 now.
10 years from the end of the assessment year.
10 years, no, I didn't even know it was increased. I knew it was increased, but not a number of years. 10 years, I have to keep it because anytime the officer will say, bring your records, I have to show you. So how can I delete it, sir? Right. So you are bound to delete it unless there is a law which requires you to maintain it for a specified year. That is as far as deletion is concerned. Let's say I give my data to a person for the purpose of some particular purpose. And I don't know how many of you have this experience. Now I find wherever I have given my name or address, whether it is the rationing office, even the passport office, they invariably make spelling mistakes. They make some nonsense out of my name. So first, I don't know, it's such a simple and a lovely name. Srikrishna is something that everybody should be proud of. They make all kinds of nonsense out of it. Now that is something that the law prohibits. When I give you my data, it's your job to maintain its integrity. Now you cannot say, why this should be my name like this, I will change it into something that is not permissible. Therefore the next is, you shall see that the data maintained by you is uncorrupted and maintained in its pristine purity. Then the next, can the bank manager or whoever is who received your data say, hey, I'm sorry, yesterday somebody came and stole your data? No, it is your obligation to maintain the security of the data. Of course, in today's digital age, the stealing is not physical, the stealing is hacking the computer and taking it away, or otherwise unauthorizedly accessing it. Therefore, the obligation is that you shall maintain not only integrity of my data, but also security of data by whatever means that is appropriate to the data that is maintained by you. See, there is a difference between the security concerns with regard to the data. Now, it's just a question of my name and my address. That may not be very serious. But if it's a question of my health data, that's a quite serious matter. Therefore, depending on the nature of data, your security measures must be appropriately decided. Now, if it's a question of data of something very valuable, like say nuclear fission data or financial data, the responsibility is all the more. So that is the obligation to maintain the security of the data. Now, one question usually arises is, now I have given you data for X purpose. Can you use it for Y purpose? Generally, the law has always been all around that no, the purpose limitation binds you to use it only for this specified purpose. But sometimes it happens that the person who takes your data, if there will be a smart chap, he will use artificial intelligence and come out with a product which he will sell in the market. So, do I have a right to stop him? The law says yes. He is not only bound to maintain the data, but if he comes out with a product that is born out of fiddling with your data, analyzing your characterizing your data, then you have a right to stop it if it is done without your consent. That is why I don't know how many of you will remember every time you apply for a credit card or a bank loan, there will be a clause which you will never read saying that I hereby consent to my data being used for blah 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 blah. There will be a long list of various things. So ultimately, the bottom line is data cannot be accessed without my consent. That is the bottom line. Now, consent is again a very tricky issue. So, how do I give the consent? The consent, as they say, must be informed consent. An informed consent is after informing yourself of the pros and cons of the circumstances, why you are giving data, what happens if you don't give the data, what happens if the consequences, etc. Now, let's say I go to whoever is the person who is taking my data, and he hands me down one long, and you must have all seen that. Now when you click a website, there is a long thing saying blah 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 blah. Do you agree? We never read it and simply say I agree. Now, is that informed consent? Technically it is informed because you are supposed to have read it, but otherwise you have never read it. Now, in a situation like that, now you are all educated persons, you are experts in English language. I am a person who doesn't understand English language. I am given long 20 pages document saying that you consent to it, sign it. Now, is it informed consent? Therefore, there is an obligation to make sure that I understand what is being asked of me. And in a country like India, where there are at least 26 official languages, I don't know whether the last number was 26, now it has increased or decreased, I have no idea. I'll assume X number of languages spoken in various states. The person who takes the data must ensure that you understand what is there. If I am in Assam, he must give me a consent sheet in Ahomas. If I am in Kerala, he must give me in Malayalam. Now, this is of course a tough job. But anyway, if that is your obligation, you have to do it. Now, even the worst, supposing I can't read and write, then what happens? How do you take my consent? Therefore, the law is that you must ensure that by some graphic means at least you make the person understand. What graphic means the law doesn't prescribe, you have to find out and implement it. Now, what is graphic means? You sit in the airport, sit in the airplane, and then some belt comes like that. That means you put on your belt. Or you sit in that and it shows a cigarette and says X on that. That means don't smoke. Or you buy a bottle and it's on a bottle of poison, I think they put a skull and cross. So these are the graphic means of driving home the point of what is capable of being consented to. So these are all about consent. Hey, but there is one area which is more complicated than argument. As students of law, all of you have studied the Contract Act, and the Contract Act says that a minor's consent is valid, invalid, void, voidable, what is it? Voidable. Void. Right from Mohori Bibi's case till today, it has been held that minor's consent is void. Now if there is a minor, and today minors are smarter than the majors, they can access the internet much more than I can do. My grandson taught me so many tricks that I didn't know existed. Now, I'll tell you an incident. When I got to London, he said, I'm going to access Khan's Academy. I said, what the hell is Khan's Academy? Never heard of it. He says, Granda, you don't know what is Khan's Academy? You sit here, I'll show you. He started the computer and showed me he was going to access the academy for learning some mathematical issue or something like that, some geometry, algebra or something like that. So he has to access that in order to learn something or learn a new language or something of that sort. Now, when he wants to access that, the academy will give him one of these click sheets saying that you agree and all that. Let's say he agrees and something happens. Now, neither can he enforce the contract, it's a contract. In law it is a contract. Neither can he enforce the contract as a minor, nor can the academy or whoever is at the other end enforce the contract because it's a void contract. And a void contract does not bring about any rights and liabilities. So that is a major issue. How do you solve it? Now, unfortunately, in our country, the age of majority depends on various things. You want to smoke, there is one age. You want to marry, there is another age. You want to do something else, there is a third age. So where do you draw the line? Is this equal to smoking, drinking, or marriage? So ultimately we said, oh look, the age of majority has been considered in the Contract Act as 18. We'll stick to 18 and go by 18. So anybody who is less than 18 is not capable of doing it. Of course, now they have made a provision in the Act that came about saying that the person who enters into contract with the major must ensure that the consent has been obtained, and if you find that the consent cannot be ascertained, he must take all steps to ensure that the consent comes from the parent. Now that's how they are going to do it, the rules we will see, and other than the rules come. So the basic ground rule is, in the case of a minor, the person at the other end must ensure that the consent has been obtained from the person who is in charge of the major service. That is over. Then various other things. Now the data in one country, may have to be transmitted to another country. Now let's say there is a Tata Cancer Hospital in Bombay. Some patient is admitted there. This is some kind of a unique situation. They want to take advice from the Mayo Clinic in New York. Now, can they transmit the data? Because without the data, the man there in the other end will not know what is exactly the situation. So you'll have to send him the PET scan and all kinds of parameters. Now, that is one thing. The other thing is financial data that have to be transferred in order to ensure easy business affairs. So in all such cases, there was always a big issue as to whether data was required to be maintained in this country or it should be maintained in another country. Now there is one other aspect of the matter which needs to be carefully analyzed. There is always an exception for accessing of data. Now I cannot walk into somebody's office and say I want the personal data of XYZ. I have to have an authority. Let's for a moment assume that there is a parliamentary enactment which empowers me as a police officer to access the personal data of somebody who is suspected of terror finding or terrorist funding or some other activity which is offensive and a crime. Now I go to an MNC and I say Mr. X and so or Miss X and so in your company is suspected of doing a criminal activity. I want to access the data. The manager can tell you, sir, I'm sorry, the data is all kept on a computer in California or in Timbuktu, wherever, and I have no access to it because I can't give it to you when you want it, and you can't take data from America and bring it here unless the American government agrees, unless the American judicial authorities agree, and there is always a law known as Mutual Legal Assistance Treaty, it's known as MLA, under which the proceeding is so complicated that it takes about, anything in government is complicated, even if the simplest thing. So it has to go through the judicial process, go through the diplomatic process, go to the diplomatic process, go to the judicial process, blah, 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 and come back the same route. It takes about average 2 years. So if I am chasing a terrorist in India and I am asking for data to make sure that terrorist is caught, I can't be told to wait for 2 years and give the data. That has no meaning. So the question was, can the law compel that the data should be maintained in this country only on a server and nowhere else? So it was proposed at one time in the original report that was submitted by the committee that you should have what is known as localization of data. In the sense, all data that is generated in this country must be maintained on a computer in this country only, so that if there is access required, legally access required, you should be able to access it then and there. Now that was objected to vehemently. All the social activists said, hey, internet is a continuous process, you can't have borders like this, you can't have an iron curtain like this, blah, blah, blah. And finally, as a compromise, the latest Act of 2022 has quietly done away with this, without realizing that two regulators in this country already shot the gun. One is the Reserve Bank. The Reserve Bank has issued its regulations and says all financial data generated in India must be maintained on a server in India. The other is the Telecom Authority, which maintains that all telecom data must be maintained in India. Barring these two regulators, everybody else is free to do what you like. Of course, there is a negative aspect in the sense that if for any reason the government wants to stop, they will stop. Fair enough. That is the way the law has been shaped ultimately in the 2022 Act. Then there is another issue that needs to be considered. When you transfer data on the fundamental assumption that here data is very secure in my hands. See, if it is an Indian situation, you are giving data to somebody and there is an obligation that he maintains it with the same level of security as it was maintained in my possession. When I am giving to somebody abroad, how do I maintain the same security level? Therefore, there is what is known as the test of adequacy. Before I can transfer data to somebody, he must ensure me that the data is as secure in that country as it is in India. Now, this of course has been sidestepped by the latest act, but it will create some problems. I expect that it will create some problems, and all our lawyer friends in India will have a field day on that. Harish not accepted. What is the situation really? The situation, I must tell you, and students of law you must know this. In Europe, there is a judgment known as Schrems II judgment. Schrems is the name of the party. See, there is a lot of activity, business activity of United States, which is housed in Europe, in various countries in Europe. And there used to be what is known as a data shield agreement, under which it was agreed that all the data would be transmitted across the Atlantic Ocean. Now this was going on for some time, till one of the commissioners in Europe objected to it at the instance of somebody, saying that how can this be done? This is wrong. And the reason given is, sorry, this is the problem with data also, it goes out of hand. Yeah, I think that's why you must know how to control it and keep it under control. One of the reasons given for the challenge was that when the data is transmitted to America, the law in America provides that if the President of the United States authorizes, any federal agency can access the data without the consent of the person whose data it is. Now, leave it to you. You can do it here. Now, the European courts said that, hey, look, in other words, what are you saying? You are saying that the data that is sent to America is not as secure as it was in Europe. Therefore, your data shield agreement is of no value and just stuck it down. Now, under the law that has been passed by the government, by Parliament today, the same situation prevails. There is no provision by which it can be protected. Now, for example, the law that is passed today has several provisions where it is said that the government may exempt any or all departments of the government or semi-government or quasi-government bodies from any or all of the sections of the Act. Which means what? Supposing the government says, none of these will apply to Department A. So the Department A data can be transmitted to anybody in the world anytime. This is precisely what was objected to by the Schrems judgment, and my own feeling is that one of these days we will face this situation when somebody in Europe challenges it and says, hey, the test of adequacy is not fulfilled in your case. When that happens, and I only hope that when that happens, all of you will be full-fledged lawyers and you will be able to fight it out for or against the country as you decide. Now then, what can be done in situations like this? Now we come to the 2022 Act. Now most of it is spelled out in some section or the other. I'm not doing, as I said, I'm not doing a visceral analysis of the Act. But I'll highlight some of the problems that I have noticed. One is this, namely that there is no way you can say the government will not access it without my consent. Somehow the right of the state has been thought to be superior to the right of the citizens and residents of this country. The next is what happens who is the regulator? Originally, when we first made the report, we had thought of a data protection authority who would be the regulator in this field, who would not only monitor usage of data and also adjudicate disputes which are in connection with data and impose fines like any other regulator, SEBI or Reserve Bank. But now the concept of regulator has been done away with. So what is brought into effect is what is called a data protection board. I must confess that in the original report that we had submitted, we envisaged that the data protection authority should be an independent body and give the important task given to it. So it should consist of an independent person like a sitting or a retired judge of the Supreme Court. It should have people, which the members should comprise people who are familiar with the subject, maybe academicians, maybe practicing lawyers, people from this country or abroad, and some government nominees, the majority being independent people. Now, that obviously cannot be stomached by any government. They didn't like the control going out on their hand. So they totally done away with the concept of regulator. And the data protection board is, according to what the minister's statement, is not a regulator at all. So I don't know what its functions are, because the law doesn't spell out who is qualified to be a member, who is qualified to be a chairman. It doesn't even say what the functions of the board are. Now, all it will be spelled out in the rules. Baki ka sab parde pe dekho. That kind of thing is going on. And as and when it comes out, parde pe aap dekh lijiye what is the function of the data protection board. This is another aspect of the matter. And I also talked about the government's overriding exemption mechanism, which really makes nonsense of the fundamental right. Now, why I am talking of fundamental right is mention was made of the Putteswamy judgment. The Putteswamy judgment said something very important, and this is, as students of law, you should note this. Fundamental rights are enumerated in the Constitution under Part 3. If you open the Part 3 and look at it, data protection is nowhere to be seen. So where did this data protection become a fundamental right? Supreme Court did a little bit of creative thinking. They said, hey look, data is something that is fundamental to a human being's dignity. That's what they said. So if Article 21 is the fundamental right of liberty and life. And life has no meaning unless it is a dignified life and not an animal life. Therefore they said, like a magician pulling a rabbit out of a hat, they said, 21, here is a data protection. And that is founded on data protection, Article 21. The important thing is, if it is founded on Article 21, it should have the self-sanctity that you give to the liberty of the human being. Now please note, I cannot be arrested without following the process of law, right from the time of A.K. Gopal until today, till they added that one odd article about preventive detention. There was a series of judgments which said that you cannot be touched unless you follow it. Now if I have to be arrested, they have to follow the criminal procedure code, follow the procedure prescribed and issue appropriate warrant, etc. Now, as far as data is concerned, which right to data is concerned, or right to privacy of data is concerned, it also springs from the Article 21. But here anybody can take it away at any time. So this is some conundrum which I'm sure somebody will debate sometime before the Supreme Court, and somebody in the Supreme Court will decide it one way or the other. Now I think I've virtually covered all the necessary topics in there, and in the next 10 minutes I am willing to answer any questions. Assuming I have time.
Yes.
That depends on you. If you have any questions arising from this, some nook or corner which I have not illuminated, and you are welcome to do it. Okay, before I start, I forgot two topics which I should have mentioned. One is the right to portability. Now, like you have, that concept is easily understood. Like you have a number, you have a mobile which is of say Vodafone, and you want to port it, to Airtel or some other thing. You have a right to do it. Similarly, my data can be ported from one data fiduciary to another depending on my consent. Depending on my wish. The other thing is the right to have the data deleted, which I mentioned earlier, but I am emphasizing it. If the data, the purpose and the time period for which the data was given is expired, I have a right as the data principal to tell the data fiduciary and say, please delete this data because it is of no use to you, subject to, of course, it is his obligation to maintain it because of tax purposes. And the third issue is, what's the third issue that I just now thought of? These are the two issues. Yeah, okay, go ahead.
Sir, as we discussed about today's scenario with regards to social media, now certainly when we share our data with social media platforms, so obviously there is a data privacy obligation on the social media platform. So it's my data, my personal data, which is there shared. However, I mean, there are when I share my data, I mean, there can be multiple things. For example, photos or anything, a blog, for example, anything in writing. And then this is accessed, or this may be accessed by some third party. Now, when it is accessed by some third party, obviously through this social media platform, so the social media platform will say that because you are accessing this data from my platform, I have copyrights on it, and then under IPR. So now, when there are two parties, one is the first party who is sharing his or her personal data, and this data then accessed by some third party through social media platform who is claiming copyrights on this data. Then whose data is this? The person or the platform?
The real context will not be with the copyright. The copyright is there. If it, let's say your data is only your name, I'm taking an example, and the social media publishes your name in a blog. Now, the contract between the social media entity and you would have provided that they have a right to put in public what is your private to you. If they don't have, then they have no business to put your name there. I'm sure there will be an agreement. Without which they need it, it's breach of your privacy. Number one. Number two, they can't claim a copyright in your name. They can claim a copyright in your name first after having obtained your consent and having done something upon your name. Then they put a nice border around your name, put some beautiful flowers and one beautiful lady saying this is so and so. That is copyright, not your name. So there is no contact between your privacy and the social media. That is the context.
Good morning, sir. I'm Megha Manu. And my question is, in this digital era, how do you see the legal aspect of the right to privacy intersecting with technology? For instance, if someone is clicking a picture in public and I unintentionally appear in the background, isn't this a breach of my privacy when this is shared online? And how do you address this misuse or unauthorized sharing of such photos in this in today's rapidly advancing technological landscape?
This is a problem I face almost every time I go to give a lecture somewhere. Somebody wants to take my photo and somebody quietly comes in there. So the question is, between the photo taker and me there is an understanding that he will not put my photo unless I take my permission. But what about the person who was sneaked into it? The photo bomber. Now you are worried about the photo bomber or me?
The photo bomber.
Photo bomber. Photo bomber obviously is doing something wrong. And look, I'm being facetious, but actually that is a complicated situation. Because the right of the person who took the photo is the copyright. That is his idea. Now, my right is my data. Now, when I allow you to take my photo, I am impliedly consenting. Right? Now, of course, the question then is whether I am impliedly consenting to your publishing it in public, or I am only giving that you may keep it in your house and put some mala and that and then the key better. This is a doubtful issue. Therefore, I would go one step ahead and say, when somebody takes my photo, there is a general implied consent that that person will use that photograph for any purpose that person wishes. Otherwise, I must get up and say, take my photo, but don't put it in your pocket, keep it in your pocket. If I am not certain, I assume that the person who takes my photograph intends to use it and publish it. That's right. Now, as far as this person, the photo bomber is concerned, you did not take photo bomber photo. Photo bomber's presence in the photograph is as irrelevant as this board or something else beside me, some furniture beside me. So I don't think that photo bomber would have a right to say, because there was no question of consent given to take the photograph in the first place, because that person just jumped into the situation. Therefore, the person actually the situation could be more complicated if instead of photo bomber, some other friend of mine was present. And let's say I'm standing here with Anil here, you take a photograph. I can't say he's a photo bomber, he's as much present in the photograph as I am. That situation is somewhat complicated, and I don't think I can give you a cut and dry answer here. It will depend on the facts and circumstances.
Your Lordship, we spoke about the purpose for which the consent is given.
Yes.
There could be instances wherein the data fiduciary may extend the purpose. Extend the purpose. I mean, suppose the purpose is, let's say, for this band, you may extend the purpose to this band without even data principal knowing or understanding for that matter. So how does the law address to this?
No, the law has addressed it. You cannot do it. That is why before you start accessing the data, you have to take consent and say, you are giving me data for X purpose, but if I do it, if I work on that, if I use my AI on that and come out with some product, do you want to claim that right on that or not? Or will you waive your right on that? If, I don't know, you have a credit card,
Yes.
you look at your credit card company's application. It would have said, this data can be used by me or any of associates for that purpose and the purpose of selling any product that we continuously do, whether it is Citibank or Axis or wherever. Exactly this is what they will say. Otherwise, they will be answerable to the law. They can't extend it technically. Therefore, they say, no, I extend it because he gave consent. Now, why did he give consent? You had no time to read the whole thing.
Sir, I have the same question in similar regard when it comes to Axis Bank particularly.
Yes,
Because when we open account, we give our cell number.
I know Axis Bank will hate me for giving this answer.
Ev-
They will bar me. They will not give me a credit card at all. No.
every day, thrice in a day, they call me and they ask for whether you wish to have loan, whether you wish to have so on. Now what happens when I open bank account, naturally I have to give my cell number because I need to get update about the account balance and so on when the debit credit takes place. But do they have authority to access this number to call and sell their product daily and disturb me thrice a day?
No, not at all. Not at all. That is why you have the DND, no?
Exactly.
The DND is intended for that, saying that shut up, don't bother me.
Exactly. Now, but what happens, now my service provider, say Idea Vodafone, will provide me 30 rupees per month and stop all the messages, unwanted or calls. In that, even I lose my account debit credit balance ka message.
Not only unwanted, but the one-time message is also stopped.
Exactly. So that becomes lost to me.
That is how my telephone is also blocked when they call you. Because your man has said, all calls stop. Now this is actually a big issue. That DND is theoretically supposed to be working, but if it works, it will block all calls.
All calls, yeah. So it's...
You see, the point is, in a day I get about 10 calls. 4 of them are known persons, so I need an act. And 5 of them are unknown, and they are not registered. So how do I know that it is not somebody who wants to do something like some legitimate business with me? So I have to answer it. Then the fellow will say, I am such a builder, 7 florid, 27 florid tower is coming up in Cup Parade or DC somewhere. Do you want to block it? I don't want to block it. I don't have that much money. So what do I do? Unless I open it, I can't. This conundrum is something like we used to play in the Supreme Court. Supreme Court, every Monday and Friday, there are at least about, we used to read about 80 to 100 matters called special leave petitions. So unless you read it, you did not know whether it is worthwhile or not. As a matter of fact, 98% are thrown out as without substance. But first you have to read it, no? So that is how the average age of the average health of the Supreme Court judge deteriorates because they keep on reading, you keep on reading, you keep on reading. This is the same conundrum here. Unless you open the message, you don't know whether it is worthwhile or not. I don't know whether technically a solution is possible because technically this is true of emails also.
Exactly.
I get about 100 emails every day, and so every few minutes I open my mobile and keep on deleting. If I don't, my mobile will stop working at some point.
Exactly.
Now this happens, I understand. Now, I don't know, maybe the technology will improve to solve this problem. And maybe artificial intelligence may be able to solve the problem. I don't know, let's see. As of today, there is no answer to that. So Axis Bank remains still big.
And moreover, it is like the Axis Bank is not someone who's calling me. It is outsourced to third agency.
Yeah, I know.
So even I can't blame Axis Bank for that.
See, I'll give you an example. One day I got a call. Some lady on the telephone, she says, your provident fund account will be, your pension account will be stopped from tomorrow if you don't give me this KYC, blah, 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 blah. So I said, who are you? She gave me some name and said, I am from the pension department of the government of India. I said, madam, for your information, nobody on this earth, not even the president of India, can stop my pension account. Luckily, I know that happened to be a Supreme Court judge. Give me your full details, your Aadhaar number, I will immediately report you to the police, and that's all the time. This happens, I can't help it. So this is some nuisance we have to face in life. Unless AI can help us. Yeah, see, unfortunately, even if you have a video telephone, you can't make it. Because some good-looking woman will come there and you'll be tempted to talk to her. And she will ask you your KYC. You will give it and get gift from it. Oh, yes, sir. Yeah, why not? Don't ask me too much complicated questions.
So just taking a cue from what you said at the end, that you can have the right to have your data deleted. Now, some years ago, the European Union particularly had evolved a new jurisprudence called the right to be forgotten.
Yes.
And that, for instance, there would be news perfectly legitimate in the public domain, which Google carried. For instance, someone had served a sentence, but paid
later on.
Similarly, someone may have been declared insolvent, now he's a discharged insolvent. And it's an antiquated piece of news. But he can then say that now this doesn't serve any purpose, I paid the price, delete it, I want to be forgotten, the right to be forgotten. Is there any such jurisprudence?
There is, actually, the Puttaswamy judgment really makes it a point to say there should be a right to be forgotten. But then the problem in India is, now everybody would like to have the establishment of the Babri Masjid is a fact of history, to be forgotten. The demolition of the Babri Masjid, forgotten. But a fact of history, can you forget it?
But that's being revived all over.
That's exactly the point. See, the historical, so for example, your example that you gave me is right. I may be convicted today of a very heinous offense, but ultimately the Supreme Court acquits me. Once I am acquitted, all my so-called criminality is washed out. But can I say, for the purpose of the record, the conviction to be wiped out? I can say this, that don't publish my conviction without publishing that there is an acquitter also. Because then they will be doing something wrong. But I can't say the court, annals of the court or the records of the court should strike off the whole thing. This is the problem with history.
Good morning, sir. I'm Dr. Sachin Pimple. I would like to ask one question. It was related to copyright and data and everything. say there's a person who would like to put any of his own created art, maybe a poem or maybe a sketch or maybe or something like that on his social media account, maybe Instagram or something like that. And see, being a common man, he may not be aware about the copyright acts and how to take the copyrights and all those things. Someone who is extra intelligent in all these things uses the same material, publishes his own name, gets commercial use out of it, gets money, maybe later on get accolades and all. Then can the original creator who has put it on the Twitter or Instagram or something like that, can he claim that it is his and not the one who is claiming, or what is the process can be?
See, first of all, copyright is not something where you have to register anything. Copyright is post-publication. If it's a question of trademark, yes. In trademark also there are two characters, two different types of trademarks. One is by registration, you get the sole authority to use that and everybody else can control it. The other is by long usage also you have that right. That is known as trademark in common. Now, the question that arises is somewhat different from this. Now, when you gave your data to the person, let's say your data is your sketch, whatever that, you have made a nice photograph of something or the other, let's sketch of something or the other. To the person who is publishing it in social media, what was your contract with him? That he can publish it freely or he cannot publish it freely. If you give him that free access, then he will say it is my copyright because I am the one who has published it for the first time. You did not publish it. You made it. It's your brain. It's your idea. But the first publication is by that child. That is what happens. This is not an unusual question. When I write an article or a book, who has the right? Me or the publisher? That is that the publisher will take an undertaking from me and I am transferring all my rights to him. Because he is the one who is publishing it. Same thing applies.
Thanks.
Good morning, sir. I have a question. How do you enforce this right, as it is not a fundamental right which is codified? So, what are the challenges that is faced by enforcing this right?
Yeah, all the fundamental rights are not codified. For example, your right to clean air, your right to clean water. Is it or is it not your fundamental right? Now, the Constitution doesn't give you a mechanism for enforcing it. Parliament has made some act, it may be in the form of Air Act or Water Act or whatever it is, which has a machinery. There will be a pollution control board, there will be inspectors appointed there, they will do it. Similarly, under this act also, there will be some kind of a mechanism. That's why if you remember I talked about the Data Protection Authority. Now, that Data Protection Authority was considered as the regulator, like the Reserve Bank or the SEBI or the EDI. Now, instead of that, they have a the Data Protection Authority was the regulator. The Data Protection Act has now made what is known as Data Protection Board. Now, what powers the board will have, what machinery the board will have for enforcing its decisions is a matter of case on my part, because the law is not at all, the rules are not at all. So I assume there will be some mechanism which would say that, hey, whoever has breached the data of another person is liable to this penalty, he can be charged before this court, some machinery will be devoted.
So this is in regards to the government. So how does, in perspective of the government, so how does the government particularly conduct national surveillance on without breaching any individual privacy of a person or the privacy data which is collected by the government?
Two methods. One is, are you sure your data is not being accessed by the government every moment? You don't know. It's possible. Otherwise, why was Israel selling all these kind of spywares? That's exactly the idea. Now that is technically not permissible, that's technically illegal. Now therefore, once the act comes into force, there ought to have been a mechanism under which state surveillance would have been permitted only for specific purposes. Now take for example, you have the right of freedom. Now your freedom cannot be breached unless there is a law which permits the authorities to breach it. Preventive Detention Act. Subject to conditions such and such, such and such, you can be prevented from going doing anything. You can be kept in detention for a specified period. Or even the regular criminal law. You cannot be arrested unless you follow the criminal procedure code. Therefore, there must be an act of parliament which empowers the government to act. And the mechanism must be such that, actually in the Putaswamy case, they have made only triple test. There must be an act of parliament, because without an act of parliament, the mere executive fiat, it cannot take away fundamental rights. Number one, it should have a declared objective. Why am I doing this? And number three, the doctrine of proportionality. Now, if you want to kill a fly, what would you use? Fly shot. Would you use atom bomb? You don't know. Very simple. So similarly, if it is possible to take the action without having to infringe your fundamental right, the obligation on the government is not to infringe your fundamental right. That kind of mechanism must be placed in place. But today what has happened is, government recheck, जो भी लिखना है लिखो, encash करो. That is something that is worrying, and it should worry every citizen of this country, every resident of this country. So start worrying from tomorrow.
Sir, good morning. I am Uttam. Sir, I would like to understand that is there any provision wherein the litigation of a common man is also masked? In the sense, whenever masked, the name masked. If you talk about rape victims, their name are always masked and it is not to be disclosed. There is a provision. But when it comes to litigation, I recently read a judgment of Rajasthan High Court wherein an advocate was privileged enough because he was fighting a case of with his wife of custody of a child, and then his name was basically masked and he was given that privilege. So is it not available for a common man, or is it only available to the advocates of High Court?
General rule is that all litigation is in public. Court is a public place, it's not a private place. Right? If it's a private affair, like an arbitration, then it is never published. But follow? Yeah. And even in a public forum like the court, the authority of the court is there always. The court can say this is a sensitive matter, where a child is involved, custody of a child is involved, or marital relations are involved, or as you say, as the Supreme Court has said often, a question of a rape victim is involved. Therefore, it can be held in trial, can be held in camera, as they call it. Now, camera does not mean this camera. In camera means secretly, without publishing it. That problem is always in the court. I don't know why the Rajasthan did. I have no idea of access to the facts. But I suppose because it was custody of the child, it must have been done. True. Possible.
Thanks.
Good morning, sir. My name is Ritika Janmanchi. So my question is, at one side we have right to privacy, and on the other side we have Aadhaar card where our biometrics are connected and Aadhaar cards are circulated everywhere. So how as a citizen we are protected?
See, as far as Aadhaar cards are concerned, the matter went all the way to the Supreme Court. The constitutional validity of Aadhaar card has been upheld in the Supreme Court. So there is no way you and I can debate on that. Of course, academically we can, but Supreme Court has decided the law. The law is that Aadhaar card is constitutionally valid. But the Supreme Court said you can't use Aadhaar card for every damn thing. Sorry, not my language. You can't use Aadhaar card. You want to go into a restaurant and order a cup of tea, you can't say give me Aadhaar card, I'll give you coffee. No, you can't do that. They have said Aadhaar card can be validly sought if a citizen or a non-citizen, the holder of the Aadhaar card, seeks some benefit from the state or state entities, for which purpose it may be necessary for them to discuss it. Now, for example, under the PDS, the public distribution system, or sorry, I don't even know the various Prime Minister, this service, Prime Minister, that service, Ayushman service, blah, 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 blah. You are asking for something. Or say, let's say I want to take my pension from the government of India. I have a right to ask for a pension, but the government has the right to say, show me your Aadhaar card, otherwise I won't give you the card. Because that's a benefit I'm seeking from the state. Barring that, nobody else has a right to ask for Aadhaar card. When people ask you for Aadhaar card for the drop of a hat, tell them to hell with you, I will not give you. I recently had gone to Bangalore And the man at the, I was checking into a hotel, the man at the counter was saying, please give me your Aadhaar card. I said, I'm the lawyer prohibited from asking for Aadhaar card. And as a judge, the former judge of the Supreme Court, I'm telling you, you can't ask for it. अच्छा ऐसा है क्या? If a manager of a hotel, of a five-star hotel, forget about it, had this kind of ignorance, you can imagine what happens to a poor man like me.
Thank you, sir.
Good morning, sir. Sir, with the emergence of artificial intelligence, metaverse and deepfake technology, few Tollywood and Bollywood celebrities have been on the target recently, and even some presidents of various other countries. And their faces and voices have been used to create a video, and because of which the citizens of those countries are getting confused. So, sir, where the line should be drawn, and what's your take on the usage of artificial intelligence without even taking the consent of those persons?
Now, whether you use artificial intelligence and create a fake video, or whether you draw a sketch of mine with funny looking face, or whether you take a photograph of mine and distort it, the law should be the same, no? That you use artificial intelligence makes no difference to me. You have unauthorizedly accessed some data of mine, and if you are publishing it without my consent, committing the same kind of risk. It is committing the very breach of my fundamental right to privacy. So, artificial intelligence is not some mantra you can put every time and say artificial intelligence. So, it's exempt from law. It is also very much, there are other areas where artificial intelligence is difficult to control. Now, hopefully that will not come to fore at all. You are asking an elementary question. Photo published without my consent, but the photo has been generated by artificial intelligence, makes no difference whatsoever. Now, the photo that I have been seeing almost every day, whether I like it or not, is of Sachin Tendulkar, saying that my daughter also does this and she plays the game and makes 80,000 rupees per day. Now, if you are persuaded by that, go and make 80,000 rupees per day. That's a deep fake, obviously, because he denied it. Now, immediately they will have to shut down, otherwise the board under the IT Act, of course, now the Data Protection Act is not coming to force as such. The IT Act is liable to be prosecuted. So I don't know whether it's still going, I have not seen it today. And I go home and check whether the Tendulkar is still there or not. Yes.
Good morning, sir. I am Sociology Professor Ritika Srivastava, and I wanted to ask a question regarding the recent case which is going on for Jindal University, that there a professor was teaching gender.
You're talking about Dalwai's case.
Yeah.
Yesterday only she met me. Yesterday exactly 24 hours before she told me, according to me the case against her is utter nonsense. Utter nonsense.
But whose privacy are we talking about? It was the privacy of the students or the professor?
Nothing. There is no question of privacy, there is no question of, harassment of women, what is that nonsense that they charge her?
But as more and more mobile cell phones are being used in the classroom and the recording, right now the session has been recorded. So in this kind of an atmosphere, how do we look at privacy here? Because
So the recording is made by implied consent by us. Otherwise I could have told him and said, stop it, don't record it.
But during a lecture, we are just delivering a lecture. Recording is not, shouldn't be implied.
When you go to a theatre, what happens? First thing they say is, shut off your mobile, no recording permitted, no video permitted. Don't they say that?
Yeah.
Then if you are still doing it, it is contravention of law. Isn't it?
Yeah.
Therefore, it was open to me to say, hey, stop the camera, don't do it, because I am going to use swear words. Yeah. I don't use swear words, so I am not worried. And I am one who will say what comes to my mind without hesitation in front of anybody. So I don't care.
Yeah.
Think if you show it to somebody.
Yeah, especially when teaching concepts of religion or caste, students really get defensive. And
so you can say there will be no recording of my lecture in my class without my permission. I am entitled to say that. That case against her is utter nonsense. I was examining it yesterday.
Good morning, sir. I'm Maya. I head PR for HSNC University. My question is related to your answer to Ritika's question earlier, and this is about in 2018 the Supreme Court said that it is unconstitutional for private companies to use Aadhaar data to establish someone's identity.
Correct.
But last year, the Union government proposed that private companies should be allowed access to people's Aadhaar data as long as such usage promotes ease of living and enables better access to services. The government's wording is very vague.
No, the government did they pass any law? No. They correct.
It was, yeah, they proposed.
करो भाई, is a business होता है. That is all. करो भाई, हम नहीं करेंगे. That's all. That is all unsolicited gratuitous advice. You use it. Look, it's always open to me to use my Aadhaar card. Nobody can stop me from. If I want to go and show that, if I want to impress you, I'll always pull out my Aadhaar card and show you because it has a nice photograph.
Yeah, the wording
But
is.
the question is, can you demand my Aadhaar card? That is the question. If, for the government to say that it is utter meaningless. If can the government pass any law, either by an executive fiat or by statutory enactment, that Aadhaar card can be used and demanded by private companies? Have they said it?
So, some cases they are doing it.
You object to it. My own case I told you, he says, no, sir, it's the most reliable proof. I said, I am not giving it to you. Actually, I gave it to him. My ID card in the Supreme Court was there.
No, for instance, I was the last person, probably amongst the last people to get Aadhaar. It's only when they made it mandatory for ID returns that I got an Aadhaar.
Correct.
In my name.
See, when you are dealing with a government entity, the presumption is that the government entity will not use it for improper purposes.
Correct.
Now, such presumptions in law are never really valid. Because we found that Aadhaar card numbers were being sold and they were putting on the website of so many companies, so many entities. Now, at least the government will give, but a private citizen, a private company cannot ask you. And the government cannot give me unsolicited advice and say, they do buy.
So property registrations, it's mandatory.
Yeah, because you are dealing with the registrar, no? With the government entity. And it's justified because the property registration is the biggest fraudulent affair in this country.
And Tirumala temple also, they made it mandatory. So without
Because
Aadhaar.
the Tirumala board is a government entity. Yeah. If Venkatesha asks you, don't give it to him. If Balaji says give it to me, tell him no sir, I will not give it to you, you are not a government entity. But Tirumala board you have to give.
Thank you so much for your acumen insight, sir. Before we conclude our event today, I now call upon Naina Abhichandani to come and announce the winners for the essay competition.
Thank you, Naina. I would now request our Honorable Justice, Srikrishna sir, to kindly facilitate the winners of the essay competition. Yes, sorry, felicitate the winners of the essay competition. I request the winners, Mustafa Kadriwala along with Uttam Israeli to kindly approach the podium.
Facilitated his winning the prize. I will have a co-conspirator. All three are legitimately in the
I request Aditya to please approach the podium and announce the winners of the Freshers Football Competition.
of January. I would now be calling out the team codes along with the names of the members, and I would request them to approach the podium once their names have been called out. Now moving on, the award for the best researcher goes to T22, the researcher, Ada Jain.
Someone else from the team?
Or one of the classmates can just...
It seems like they are not present. We can... Moving on, the award for the best speaker goes to Team 12, Speaker 1. Hilji Jhangi. The award for the best memorial goes to Team 3. The team comprises Johan Patel, Zal and Saket. The award for the runners-up team goes to Team 5. The team comprises Azra Kiwala. And lastly, the award for the best team goes to Team 12, Hilji Jhangi, Uttam and
Thank you, Aditya. I would now like to request Advocate Shobha Jagtiani ma'am, Advocate of Bombay High Court, Trustee of D.M. Harish Foundation, to please felicitate our dignitary guest today, Honorable Justice B.N. Srikrishna. Thank you so much, ma'am. I would also now like to request Rinda, please come and propose a formal vote of thanks.
Thank you so much, Prerna. Good morning to one and all present here. On behalf of DMHSL School of Law, HSNC University, Mumbai, it gives me, Brinda Hamnu, a privilege to propose a formal vote of thanks. I extend my sincere gratitude to our esteemed guest speaker, Honorable Justice B.N. Srikrishna, for graciously accepting our invitation and enlightening us today about the right to privacy and the law, drawing from his extensive knowledge and practical experience in the field. Thank you so much, sir. I would also like to express my gratitude to Mr. Ali Hari, sir, Trustee and President of HSNC Board, for addressing us and being present with us here today. I also extend my sincere appreciation to our Honorable Vice Chancellor, Dr. Hemlata Batra, for encouraging us to conduct such events. A special acknowledgement to Advocate Shobha Jagtiani ma'am for gracing the event and providing encouragement to all of us. I would like to announce that Mr. Harish Jagtiani will be engaging a virtual lecture on professional ethics clinical on Monday at 6 p.m. I extend my sincere thanks to all the teaching and non-teaching staff, the organizing committee members and the technical staff of HSNC University for their dedicated efforts. We look forward for hosting you for many more enlightening lectures in diverse areas of law. Thank you once again. May I now request everyone to stand up for the national anthem.